So many of you, welcome to Facebook Live. We're streaming Facebook Live now. So from Crawford and Twigs, hello and welcome everybody from Fort Valley's page as well as the Law Center. This, as I said, and hopefully you've been enjoying our slideshow that tells you a little bit about us. But I am Brenda Maddox. I'm Family and Consumer Science Agent for Fort Valley State University Extension, and I serve in Marion County, Georgia. This is a collaborative program between Fort Valley State University Extension and Georgia Heirs Property Law Center. And we're excited to have you. We thank you. And today we are going to go ahead and get started. Want to say thanks to everybody on the committee. A lot of people are what made this program possible for you today. And so we're going to go ahead and welcome everybody. Thanks that everybody made it through the inclement weather last night and made it safely here. So we're grateful for that as well. To As I said, this collaborative program from Georgia Heirs Property Law Center and Fort Valley State Extension, and I'm going to have the pleasure of introducing our speakers this morning. A few notes before I do that. Again, mute your microphones and let them remain muted during the program so that the speakers don't get any feedback. But we love seeing your faces, so thank you for opening your cameras so that we can see you. Our questions will be handled by the attorneys during the program, and we ask that you type those into the chat. So having said that, I'm going to go ahead and introduce our the chief operator, founder of the Law Center, and then we'll move forward as our program is outlined. Our the person actually that will be handling our questions today is taking a back seat, and she's Skipper G. Steitmas, and she is the founding executive director of the Georgia Heirs Property Law Center. Miss It's also known as the Center, and Miss Steitmas has more than 25 years experience in community economic development as a community economic development attorney, and she specializes in heirs property and nonprofit land-based development projects. Also, those projects involve some very complex real estate acquisitions, conservation easements, farmer cooperatives, and affordable housing developments, and also leasehold agreements. Ms. Sightman has formal experiences of growing up actually on a farm in rural South Georgia and becoming an heirs property owner herself at the age of 8 years old. And that's what has actually brought her to her work here today. Ms. Sightman manages a staff of attorneys and social workers, a paralegal, and they're all located from places to Atlanta, Athens, um, Valdosta, and Fitzgerald. And they accomplished this work throughout Georgia in those areas. And under her leadership, the center has prevented the creation of heirs property through estate planning and providing assets education to grow generational wealth and to uh, and through home and landowner uh, re- uh, remediates and entanglements through technology assistance and emphasizing a loss prevention and building assets. And this basically why we're here. And they've been helping low to moderate income families throughout the communities in Georgia. And we're excited, as I said, to have them here. It's not every day you get free advice from attorneys. So we thank you for joining us, and we thank them for having us. Skipper Steitmas, I'm going to turn it over to you now, and she will introduce her staff.
Thank you, Brenda. That was a lot of words to say. I grew up in Brooks County. I became an heirs property owner, and I've spent my life studying this issue and trying to figure out how to resolve it. And I'm old enough to have done a lot of work. That's that sort of sums up that introduction. But I'm glad to be here. My heart's still down in South Georgia. I've learned a lot over the years, and it's great to be able to bring it back to the people. Let me take just a quick moment and introduce my staff. If y'all would speak up, turn your videos on if they're not already on, and just say hello real quick so people can actually see you. Delene Porter is our Chief Operating Officer.
Hi, everyone.
And Gentry Mander is our Legal Programs Director. Gentry, are you there?
Yeah.
Oh, there you are. Wanda Strickland is down in our Valdosta office and is a staff attorney.
Hey.
And then Libby Summerall is our paralegal.
Good morning.
And we have an intern with us, Bailey Miney.
Hi, everyone.
So there we are. So with that, let me get started. I think that Libby's going to actually put the our PowerPoint up. So this is estate planning basics, what it involves and how to talk about it. So first, a quick thank you to all of our partners and participants, Fort Valley State University, incredible folks there. Fort Valley State University Cooperative Extension, University of Georgia Warnell School of Forestry, Golden Triangle RC&D, Georgia Forestry Commission, Southern SARE, and of course, the Georgia Heirs Property Law Center. So like any good attorney, we have to tell you that this is an educational program and is not providing direct legal services. For direct legal services, you would need to contact the center directly, and we would take you through our intake process. So our roadmap for today, just so you'll know what's coming, is we're going to talk about what the center does. What is estate planning? What happens when you die with a will? What happens when you die without a will? What heirs property is and why it's a problem, how heirs property impacts us all. Then we'll wrap up, and we do have some information about how to take care of your documents and questions. We also have an appendix that you can access. During the program, what's going to happen if you have a question, and I hope you do, you'll submit it via chat on Zoom or on Facebook Live. And then throughout the presentation, there will be pauses. And during this time, myself and Wanda Strickland, our staff attorney, will take the time to answer your questions. So let me tell you a little bit about the Georgia Heirs Property Law Center. We are a nonprofit law firm, and we have the mission to build generational wealth, economic value, and community stability by securing and preserving property rights. We're a bunch of attorneys with a support staff, and we work with a network of pro bono volunteers and grassroots organizational partners, and we are statewide with geographic focus and outreach in Atlanta and South Georgia. And we have offices in Atlanta, Athens, Fitzgerald, and Valdosta. So what do we do? Excuse me. We work in 3 buckets. One bucket is the legal support for families, individuals, nonprofits, and municipalities to actually identify title issues and then clear the titles. And we use several different strategies in clearing titles. And the second bucket is land loss prevention services, which most attorneys call estate planning, meaning that we develop estate plans with the intention of preventing heirs property. And this presentation today squarely falls in that bucket. And then our third bucket is asset education. We work with our clients and with the public in general on helping folks find resources and develop plans for growing their home or their land as an asset. So with that, I'm going to turn this over to Gentry.
Yeah.
Yes.
Hey, so I'm going to take y'all through what is estate planning. Your estate is considered all of the property and possessions that you own. So those can be personal property, that's things you can pick up and move, or real property, which is home or land. And estate planning is a process of making plans for what happens to you and your assets when you pass away or when you become incapacitated. So it asks questions like, how are you going to hold the title to your property while you're alive? Who will inherit your assets when you die? Who's going to make healthcare decisions if you're unable
Gentry,
Yeah.
I don't mean to interrupt you, but we're having a hard time hearing you.
Not sure what to tell you.
Okay, well, give it your best shot.
Okay. So where was I? So some of the questions we ask in estate planning is who's going to make healthcare decisions for you if you're unable to make them yourself, and who will manage your assets if you become incapacitated. So a complete estate plan consists of 3 documents, which is your advance directive for healthcare, your financial power of attorney, your last will of testament. Your estate plan may also include nominations for guardians and conservators or trusts. Just depends on your needs. So people ask us a lot, this is one of the common questions, is who needs an estate plan? And everyone needs an estate plan. As I mentioned, estate plan is not just if you own something. It's also what happens to, who can manage things if something happens to you while you're still living. So if you're incapacitated. So an estate plan makes sure that the right person is making decisions for you and that your property goes as you wish. So the first one we're going to talk about is an advance directive for healthcare. The advance directive, so it's short way I'll refer to it, performs 3 major functions. So the first is that it allows you to nominate a healthcare agent who will make decisions when you are unable to do so. It allows you to to select your preferences for how you want to be treated in the event that you are unable to make those decisions yourself. And it allows you to appoint a guardian in the case that a court decides you need one. So it does not appoint a guardian at that moment. It's more like nominating. So should a court decide you need a guardian, it's letting you have some say in who the court picks. So it's not a stranger or that child you don't like. Go ahead, Libby. So any adult who's 18 years or older can be your agent, as long as they don't have any conflicts of interest with you. So that's going to be rare. So the person that you select as your healthcare agent is not required to accept the appointment. So it's a really good idea to speak with that person, let them know that you're thinking about appointing them your agent in your advance directive. And it's also a great idea to talk to them about what it is ultimately you want done with your body when you pass away and what sort of treatment you want if you're in the hospital and can't speak for yourself. So when I talk about the treatment preferences, we're talking about in the case that you are in a permanent state of unconsciousness. It used to be called a vegetative state, but it means that there's no brain activity and they are unable to communicate with you by any means. So this is not if you were just in a coma. This is if 2 doctors in writing say there's nothing we can do to bring this to cure this person or bring them back to functioning, but we can keep their body alive. And so in that case, you have the option to say, hey, I want you to do everything that's possible to keep me alive as long as possible. So that includes a ventilator, feeding tubes, intravenous hydration. The other option is do nothing. I just want pain meds, but otherwise just let me go if I'm at that point. And then the third option is kind of you can craft what makes sense for you. So you can say, I don't want a ventilator, but I do want a feeding tube, or I don't want a feeding tube, but I do want supplemental oxygen. And so sorry. So physicians have an oath to keep you alive. And so if you want them to not take any further steps to keep you alive, then you have to have in writing clear and convincing evidence that that is what you wanted. So this is a very important document to have in your estate plan. So the guardian section, in certain circumstances, you may need a guardian to care for your person, so your general health, safety, and well-being. The healthcare agent's only controlling very specific situations. And so a guardian gets appointed if a court finds that you lack capacity to make responsible decisions for yourself and that the appointment is in your best interest. So instead of the court having full say over who that guardian is, you can nominate a person to be your guardian in advance. The financial power of attorney is a very broad document that allows you to appoint somebody who will conduct your financial affairs if you are unable to do so or don't want to. This needs to be somebody who is immensely trustworthy, because it's very broad power. So your power of attorney can do almost anything you can do with your assets. And so generally this allows your agent to sell property, to pay your bills, to manage your stocks and bonds, to continue operating a business for you, to donate money as you donated money, to pay your taxes, to receive benefits from government programs. So it's really important that it's an important document to have, because you might be perfectly fine now, but you never know when you might no longer be, and you cannot execute this document when you're incapacitated. So it's important to have now while you're coherent and lucid, in the case that you either temporarily or permanently become legally incompetent and can't take care of these things on your own. Typically, a financial power of attorney takes effect immediately. There are exceptions to this, but it's rare that we would do those for a client, or rare circumstances. But the agent must have the document in their possession in order to utilize their power. And an agent's power ends upon your death, upon assigned revocation, or upon the appointment of a conservator. So oftentimes we see people, while mom was living, she nominated a child to be her power of attorney, and they think that after she's passed away, they still have power to do what needs to be done, and that's not the case. As soon as you pass away, it's either it's your personal representative, so who you nominated in your will, or who steps forward and gets appointed by the court to handle your affairs. Guardians and conservators. So the primary responsibility of a guardian is to make decisions about the support, care, education, health, welfare, and general well-being of minors or an incapacitated adult. So there's 4 common types of guardianships. There's the standby, temporary, permanent, and a testamentary guardianship. So the standby it allows a natural guardian, so a parent, to designate somebody to be the guardian for their child for a limited period of time in the case that mom or dad is still living but can't care for that child themselves. So that's this is a document that's outside of somebody's will, and it provides a temporary protection for your child, and so that nobody's fighting over it. It's nice and clear who's supposed to take over in that time period. Temporary guardianships, similar but a little bit different. This temporarily allows someone else to become the guardian of the child. This is not for natural parents. And then the permanent guardianship is only permitted when both parents are deceased or the parental rights of any living parents has been terminated by the court. So this is if you were like giving guardianship permanently to another person, and this can only be done if mom and dad are both deceased or if either of them have given up their rights. And then a testamentary guardianship is one in which a guardian is nominated in the will itself. A conservator receives, collects, and makes decisions about the assets that are owned by a minor child or incapacitated adult. So a guardian is concerned, I think of it as like guardian's concerned about your body and your well-being, your person, and a conservator is concerned about what you own. These can be nominated in a will, a financial power of attorney, or there's a petition allowing you to nominate a conservator. Trusts. So a trust is a confusing, nebulous concept, but it's an entity created by a person that holds assets that are managed by a trustee for the benefit of somebody else. And that somebody else is called a beneficiary. Trust can last 360 years in Georgia, and so it's really important that you work with an attorney on a trust. There are many different kinds. I'm just going to go over a couple that you might have heard of, or if you don't know the term, you may have an understanding of the when it's utilized. So a testamentary trust is one that's created in the words of a will. Usually these are to hold assets that are gifted to somebody who's under 18. But also it could be for adults who are incapacitated or who need somebody to manage those gifts for them. A revocable living trust, it's also known as an inter vivos trust. So revocable means that the trust can be revoked at any time. And the living or inter vivos part means that it's created while the grantor is living. So as opposed to a testamentary trust, which comes into existence upon somebody's death, an inter vivos or a living trust is created while you're living. Typically, a trust like this is used to avoid probate and to maintain privacy. They're really common in Florida. You may have relatives in Florida. It seems like everybody has one there. And that's because the probate process in Florida is especially challenging. In Georgia, things are a little bit simpler, and this may not be the best fit for you. And so that's why it's important to consult with an attorney. Even if you have a revocable living trust, you still need a will. And that will fills in, it's kind of like the backup. It makes sure that everything gets included into that trust. And then there's a special needs trust, which is used to preserve and protect the ability of either a child or an adult with special needs to continue collecting means-based financial assistance, such as Medicaid or Social Security. So this is a very tight trust, and it's you have to have very specific language based on the rules from the federal government that limit the way that the assets in the trust can be used, and so that the assets are not considered accessible by the person with special needs. And this can be created in a will or while somebody's living. Do we have questions at this point?
It's Gentry. Go ahead, Wanda.
Hold on just a second, please. Wanda is actually going to handle some questions at this time.
Okay.
I'm sorry, Brenda, I realized that was you speaking. Did you have something?
No, you're fine. I just wanted to make sure that we were on track with Jalene's. We're going to take the questions here.
No. Okay, Wanda, you want to jump in?
Okay.
Yes. So we got a really good question that kind of combines what we were talking about with powers of attorney and guardianships. And so the question is, just in a nutshell, we have a couple, husband and wife, and the husband is mentally ill and medically non-compliant. He is refusing his medication and apparently any medical interventions. He cannot make his own decisions at this point. So the question is, how would his wife get control over his assets? Probably himself and his health care and that kind of thing. It does kind of depend on the level of his mental illness. If he is non-compliant with his meds, but he understands what's going on, and he, is not, actively psychotic or hallucinating or whatever. If he can make some decisions, then he could willingly execute a power of attorney if he understands what he's signing. So, it's hard to know without seeing the person if he is capable of making that type of decision. If he's not capable of signing a power of attorney, or if he's unwilling to, which it sounds like he might be unwilling to since he is kind of against treatment and so forth, then the only other option would be for his wife to file to get guardianship over him. So, and the person is actually saying, so he may be willing to sign the power of attorney. So just the main thing is that he needs to have capacity to be able to sign power of attorney. So he certainly doesn't need to be in a psychotic state or, just delusional or anything like that. And if, an attorney that drafts that type of document for you, is going to meet with that person and do an evaluation himself to make sure that that person has capacity to give that type of power. And so also some other questions that we've had involve the power of attorney. Again, asking, does it have to start immediately? Is there a way to postpone power of attorney so that it begins at a different time? And of course, it always ends when the person dies. But a general power of attorney, like a financial power of attorney, a durable power of attorney, those do actually begin whenever they are signed. But there is another type of power of attorney that I think most attorneys don't like, and that's a springing power of attorney. And that is when the power doesn't go into effect until a particular event takes place, such as maybe, you would have to state the specific event that takes place, such as being admitted to a mental hospital, or maybe, being in a comatose state or something like that. And those are really not very good practice, because it sometimes takes a while to actually get that power of attorney in place once that event happens. And so delays like that could actually be detrimental to the person you're trying to help. So, so we definitely recommend having a power of attorney that starts immediately. So if something happens the minute you walk out the door, you've got somebody that's gonna take care of your things, take care of you, and make sure that, that everything's okay. So.
Thank you, Wanda.
You're welcome.
So,
Thank you. Skipper, did you want to pick up where we are? Because we're moving to the lien now, if there are no other questions, right?
so Libby, you want to advance? There wasn't a question that came in by Facebook chat, but we will save that for the next question slide.
And Brenda, I'm going to turn this over to Gentry and pick up in a few more slides.
Okay. Thank you.
answering questions in the chat box. It's not my job, but I can't help myself.
So Gentry,
Yes.
I believe we're moving to you now, according to Zelene.
Yes. Can y'all not hear me at all?
It's going, we can hear you, but it is going in and out a little bit when you shake it. Try it again. Let's see. Say something.
So what is a will? A will is a document that leaves instructions for what will happen to your assets and who will care for your children or any incapacitated adults that you care for when you pass away. So, you know, the obvious function, what most people know, that a will gives you your assets to other people upon your death. A will also allows you to appoint an executor that will manage your estate. It allows you to establish any testamentary trusts that you may need to protect assets that you're giving to minor children or incapacitated adults. And it allows you to nominate a guardian and conservator to protect the interest of minor children or incapacitated adults. I can't stress enough how important it is to work with a licensed attorney to prepare your will. I know there are forms online. I know 90% of people think they have very simple needs from their will, but believe me when I say that every day I come across a will that was done wrong. And I'm always surprised by the little ways that things can get screwed up that make a big difference. So it's just best to find an attorney and work with an attorney who specializes in estate planning. So a will ensures that your wishes are carried out as you want them. And it ensures that it's done by the person that you have chosen. It allows you to leave your property in a way that does not create heirs property. It allows you to pick somebody who you trust to care for your children or incapacitated adults that you care for. It protects the financial interest of your family. It allows, if you include your family, it allows your family to be part of the decision-making process in advance. You have the chance to speak to your children and say, this is what I'm thinking, this is what I'm putting in my will, so that when you do pass, your children don't say, what? That's not what mom wanted. I can't believe she did it like this. It lets you clear the air while you're alive, and it's a really nice opportunity to provoke those conversations with your family. And it gives family members time to grieve without arguing over, well, I know that mom wanted this, or I know mom wanted that. When you never have, you never put any of it in writing, people they have their own ideas. And so it's a nice way to just clear the air and make it very obvious what it was that you wanted. So a last will and testament can, does a last will and testament prevent heirs property? It can, if it's drafted in a way that prevents heirs property. So if you leave your property to all of your children without giving your executor the power to sell, you are creating heirs property. So just having a will is not enough. What you should think about are leaving your property in certain ways so that you do not create heirs property. And here are some of the ways you can do that. You can select one beneficiary. So you leave your home to one child. Or you instruct your executor to just sell the property and divide the proceeds between your children. You can give family members the option to purchase one another's interests. Or you can instruct the executor to physically divide land among the beneficiaries, if that's feasible in your situation. So even if you own an interest in heirs property, you would still benefit from careful will drafting. Because so let's say you have a fractional interest in property. If you leave your fraction in a way that does not exacerbate the problem, you are helping to solve the problem. So if you own a quarter and you leave it to one person, they own a quarter. If you own a quarter and you leave it to 4 of your kids, now you've got 4 more people owning, each owning a 16th.
you do not need to wait until your heir's property issue is resolved to begin an estate planning conversation. I will go over these. So a few important terms that you'll see in a will, and I may have already been using, is a decedent. That's a person who has died. A beneficiary is a person who receives something from a will, as opposed to your heir. An heir is a person who would receive something by law if you do not have a will. Beneficiary is who you have picked in your will document. A descendant is the lineal descendant of a beneficiary, so that includes children and grandchildren, but not your spouse. An executor is the person who is named in your will to handle the estate. This is different from an administrator who is appointed by the court when you do not have a will. Collectively, we refer to executors and administrators as personal representatives. So you may hear any of those terms. And then per stirpes is the distribution, is how your estate is distributed if a beneficiary passes away before the decedent. So it just says who takes and in what proportions and how, if say your child passes away, how do the next descendants take? So the standard things you're going to find in a will, they identify your heirs, your spouse and your children. It gives instructions for how your body should be disposed. A little comment on this. This is commonly where the disposition of your body is found, but typically by the time a will is found and read, your body has already been disposed. So you also typically put how you would like your body disposed of in your advance directive as well, because that's a handy document that people have more readily accessible. It gives instructions for dealing with your debts. Instructions for distributing your home, your personal possessions, your vehicle, cash, stocks, bonds, and any other assets. It identifies your executor and lays out the power that they will have, and it may create testamentary trusts or identify guardians or conservators. So you can, most of your assets you can distribute through your will. So home or real property, no matter how you own it, your vehicles, any personal property, again, things you can pick up and move, or money from your bank and investments. Your will does not distribute home or real estate that's owned as joint tenants with right of survivorship. So these are special words that you would find in your deed. And if you own a property with another person as joint tenants with right of survivorship, that other person automatically receives your share upon your death. So this is a great way to own property with a spouse, since it simplifies the process upon the first spouse's death. Life insurance policies are passed by a beneficiary designation form, and it's recommended that you leave it to specific people and not to your estate. Retirement accounts, pension plans, 401ks, these are also best distributed by the beneficiary designation form to an individual. And we recommend that people check in with the providers, the people, the companies that they have their life insurance or their retirement with, and make sure that their beneficiary form says what they think it says. Those companies sometimes merge or change, and your beneficiary designations don't always transfer smoothly. So it's a good idea to do a check-in every now and then. Joint bank accounts or bank accounts that are payable upon death, those transfer automatically regardless of what your will says. And assets held in a living trust also do not go according to your will. They go according to the terms of the trust agreement. Anybody 14 years or older can have a will. It needs to be in writing, freely and voluntarily signed, in the presence of 2 disinterested witnesses, and it needs to transfer assets upon your death. Georgia does not recognize oral or unwitnessed wills. A will does not have to be notarized to be valid, but it is recommended that you also sign what's called a self-proving affidavit, in which you and the two witnesses, as well as a notary, swear that the will was executed properly. So when you die with a will, other way, I think, it's called dying testate. So you had your will decides who inherits, who's the executor, who's the guardian. If you leave property to more than one person, you still have created heirs property with that will, and the will must be probated. So it needs to go it needs to be filed along with a petition in the probate court, so that the probate court will appoint the executor officially. So the will nominates you, but you do not have, the executor does not have power until they are appointed by the court. When you die without a will, you are considered passing away intestate. When you die intestate, the Georgia code decides who inherits. A judge decides who becomes the administrator, who becomes a guardian, and if you own real property and have more than one heir, you have definitely created heirs property. Dying intestate is a problem because Georgia gets to decide all these things that you could have decided yourself. Your assets are divided equally, and maybe you didn't want them equally. Maybe maybe one of your children has a greater need than others, or maybe you just don't like one of them. So intestate succession, it creates an increased risk of family discord and disputes, that it opens the debate for what it was that mom wanted, and it often creates heirs property. So the rules of intestate succession is complicated, and I think I'm talking too much, so I'm just gonna kind of go through this quickly. But this is who inherits if you did not have a will. So everything goes to your spouse if you only have a spouse. If you have a spouse and children, it's shared between the spouse and those children. If you only have children and are not married, then it's shared equally by your children. If you do not have a spouse, children, or other descendants, it goes to your surviving parents. If you don't have any of those, it goes on to your brothers and sisters. If you do not have brothers or sisters, or a spouse, or children, or descendants, it goes to your nieces and nephews, etc. So the state will try to find somebody, but if you have no surviving relatives, then your estate will become the property of the state of Georgia. It's very uncommon. All right, any more questions?
Okay, so we've gotten a couple of really good questions in. One of the questions was, who inherits our estate? My husband, if my husband and I do not have a will and we don't have any children. So there is a statute in Georgia that lists out the laws of intestacy, and if you don't have any children, everything would go to your spouse. If your spouse has predeceased you and you have no children and your spouse is predeceased, then it would go to your parents. If your parents have predeceased you, then it would go, and your spouse has predeceased you and you have no children, it would go to your siblings, and it builds out from there. So I don't actually have the number of that statute in my head, but there is a whole process that the state laws have for how to distribute your estates if you do not have a will. Another question that was asked was, is a handwritten notarized change to a living trust okay to include as a legal document regarding how I would like assets distributed? Without seeing that document, I actually can't answer that question. I'm not sure whether or not you're talking about a codicil to your will and what you are referring to as a living trust. So again, it's a really good example of why seeing an attorney would be helpful. So this one says that there is intestate, there's no will, there are 5 children, 6 real estate properties. How will it be divided? So if there's no spouse and there are 5 children, it would be divided, all of the 6 real estate properties would be divided equally among the 5 children. If there's a spouse, it would be divided between the spouse and the 5 children. Thank you for sending out the statute for the intestate rules. And then this one is, what if a parent, it's funny because you guys weren't asking any questions and then suddenly they all started coming in, but it's great. What if a parent has passed and owns property and didn't have a will? The parent has 3 children. What can the grown children do if they want the property? So that is effectively the creation of heirs property, and we will address heirs property a little later in the program. A lot depends on what the children's plan is and whether or not they get along, and what this particular situation, if there was a spouse, and whether or not the spouse predeceased the parent. So that's a complicated question, and not one that can be easily answered. I don't have a magic wand to give you an answer. Should a will be filed with the court once it's established? So a will can be filed with the court in order to have it held in a safe place. I believe that later in the presentation we talk about how to keep your documents. It's not necessary for you to file it with the court, with the probate court, but you can. And then I believe this might be, let me go back. Okay, yes, I believe this question that came in refers to the 5 children and the 6 properties. Do the properties have to be sold and divided? Will the judge decide who gets what if one of the 5 have an issue? That is a complicated question, and not one that can be answered. I certainly can't tell you how a judge will decide, but there are several options before having to sell and divide the property. So, and then the last question I'm going to take before we jump back into the presentation is a copy of the presentation available to the participants. I believe that someone sent out the information of where this presentation would be, the recording of the presentation would be after we've concluded it. So with that, I'm going to pass it back to Delene. Thank you.
Yes, thanks. All right, so now we're going to jump into our discussion of heirs property and why it's a problem. And if you weren't anxious already coming through Gentry's portion about estate planning, this will definitely put you over the edge. But don't worry, we can bring you back. So let's start with what is heirs property. Heirs property is a home or land that has passed from generation to generation in such a way that multiple people, multiple family members now own the same piece of real property. So thinking back to Gentry's list of the intestate succession, where the state of Georgia determines how ownership occurs if there's not a will in place. So quite often, as many of you might know from personal experience, the last known recorded deed, so the deed that has been recorded in the court of the Superior Court in the courthouse where the land is located, typically that deed is in the name of a deceased relative. So it might be in the grandfather's name, or the great-great-grandmother's name. And often this is referred to as fractured or tangled title because multiple people have an ownership interest in that property. And as Gentry mentioned again, heirs property can be created with a will, when they leave it to multiple heirs at the same time. And then, of course, without a will, and then that ownership uses the Georgia state law of intestate succession. So if you're thinking to yourself, oh no, I think we have heirs property in my family, you are not alone. Back in 2017, USDA and UGA Carl Vinson Institute of Government did a study. They were looking at various counties and tax assessor data, and they determined that between 11 and 25% of the parcels in any of those counties was probable heirs property. So that is a lot of land in the state of Georgia. And when we extrapolate that out to all 159 counties, that's about 34 billion in tax appraised dollars that is essentially locked capital, frozen capital. So we sort of think of heirs property like a pile of cash in a glass box. The family can see it, but they can't access it. So, obviously heirs property is created every day when someone dies without a will or with a will that leaves it to multiple heirs. And the impact isn't only at the family level. In a neighborhood, whether it's the home down the street that no one is keeping up anymore because no one's in charge. For municipalities, it causes blight, code enforcement issues, tax base erosion. Nonprofits have a hard time fixing up homes when there's not an owner occupant involved. And then, of course, state and federal agencies aren't able to deploy their dollars into the community, like after a natural disaster. FEMA can't spend money on a home that is not owner occupied. And then qualifying for things like home repair programs through whether it's the USDA or conservation easement programs through NRCS. So it's prevalent and it's a problem in lots of places. So just as a recap, here's how that line of succession goes. So let's say this home is owned by mom. She's the only person whose name is on the deed, and she passes away, and she leaves a husband and 6 children. So all of a sudden, dad doesn't get the entire ownership of the home or the farm. Dad now splits the ownership with the 6 children. So there are 7 people who technically own this piece of property. One step further, mom has passed away. Dad and only 4 of the children are still alive, but the 2 children that have passed away, they each have 3 children. So now all of a sudden, dad owns the property with the 4 remaining children and now 6 additional grandchildren. So we're starting to talk about multi-generational kind of ownership structure. And then the last one that I'll just go over quickly is those 2 children that had predeceased mom, passed away before mom did. They were married when they passed away. So now all of a sudden, dad and the 4 original children co-own the property, not only with the grandchildren, but also with the spouses of sort of the in-laws. And it just gets more and more complicated. So again, heirs property is created with or without a will. And it's not enough just to have a will. You really need to purposefully prevent the creation of heirs property. So what does that mean when, for example, all of these people, the grandkids and the in-laws and the widows and widowers, everybody has an ownership interest. The law sees these owners as tenants in common, which means that each heir has equal rights to full use and possession of the property. So those grandkids, great-grandkids, technically they're allowed to come open the front door to the home and walk in and sit in the living room. And, the widow in-law is allowed to walk across the farmland. Each heir is legally responsible for the taxes and other property related expenses. This is another one that oftentimes doesn't work out. There's always, the one person who puts it together and pays the taxes every year, and the rest of the heirs are nowhere to be found when the tax bill arrives, or when a major repair needs to be made. Each heir may transfer interest in the real property to another heir or outsider. So we see this often, especially with developers who are trying to get their hands on a piece of property in an urban area that is rapidly under development. They buy an interest of an heir out, and then they attempt to force the other heirs into a sale. We also see it quite frequently with folks who are amassing more land for timber or farmland. They'll attempt to buy the interest of one of the scattered family members, the heir who lives in Chicago who no one's talked to, and he hasn't been to the family farm down in, Thomas County in years and years and years. A developer will buy his interest out and then attempt to use that position to leverage getting the rest of the land in their control. An heir may seek a partition of the real property. So, one heir can show up and say, I request that this property be subdivided so that I can have, my part. And then each heir must agree to any major decisions about the real property. And this is where we see that example of, we had a woman who wanted to qualify for a home rehab program where the community nonprofit would fix the roof on her home. And she wasn't the owner of the house. It turned out she owned the house with her nephew. And in that situation, the nephew wasn't interested in signing his interest over to his aunt, but he was willing to sign a power of attorney to give her the authority to enter into the working relationship with the nonprofit to actually fix the roof. So trying to figure out how you empower one person or an entity like an LLC or a trust to make decisions so that you don't have, consensus among a bunch of people who might not all be on the same page. So why is it a problem? Yes, some of these are going to be very obvious. Of course, if you're living in heirs property, it drastically increases the risk that you could be forced to sell or forced out of your home. Heirs can't sell, mortgage, or lease it like on the open market for the best value. It's it's difficult farming or qualifying for any of the ag loans like EQIP, or selling agricultural products. So let's say you and, your aunts and uncles and 20 cousins own a piece of timberland, and it would be wonderful to be able to sell the timber to pay the next round of property taxes. Well, technically, without some elaborate written agreement amongst all of the legally entitled heirs, you can't really sell the timber in a way that would be legal, essentially. So that's a problem. You really do need to clean up that title. It's hard to qualify for the home repair programs or secure financing. Again, the government programs like USDA, HUD, which is Community Development Block Grant dollars, CHIP dollars, FEMA, any of the natural disaster recovery dollars, whether it's for natural products on the land or for a home that has been destroyed. It's very difficult to do loan modifications. We have examples where, the wife and husband, they refinanced the home, and in the process it got refinanced just into the husband's name, so not both of their names. And when he passed away, all of a sudden the mortgage company was saying that it wouldn't deal with the wife because she was not on the title, and so having to intervene so that that home didn't enter into foreclosure was critical. And then this is actually another way many people figure out that they're in heirs property. They go to apply for homestead exemption. They're older and they can get a tax break, and they go in and they find out that, well, technically the deed's not in their name, and therefore they can't sign up for homestead exemption. So heirs property definitely, it causes family disputes and discord. Normally reasonable people can act completely irrationally. It can result in, you losing the family home, the farm, or a sense of community. And then, of course, a loss of a sense of independence that comes with that sort of real property ownership. So don't worry. Once you've cleared your title, there are lots of things that you will be able to do with that asset. You can, of course, manage your timber and sell it for the highest value, timber and agricultural products. You can engage with organizations like the Georgia Forestry Commission will come out and be able to help you create a timber management plan. You can utilize the USDA agricultural programs, EQIP, some of those conservation easement programs, potentially where they would pay you for an easement. You can, of course, then take advantage of some of the property tax reduction programs, the CUVA sorts of things. You can pass that property on to the next generation with clear title, which is incredibly, what an incredible gift that is in terms of generational wealth building. And then you can enter into leases or contracts for the property. So, you can enter into a lease to allow somebody to hunt on the land, those sorts of things. And then, I think that's the difficult, heartbreaking thing about heirs property is that it really does rob that next generation of wealth and a means of building wealth over time. So, if you've got that clear title, you can open a line of credit or apply for a mortgage. You can use the property as collateral for a loan. You can lease it. We have examples of folks who were able to gain control of a home and then were able to start using it as an Airbnb to generate some income, obviously pre-COVID times, but hopefully we'll be back there sometime. And of course, generating income off the land, so forest products, farming or selling the natural resources. You could sell the property if it's time for you to sell the home and move to be closer to children or something like that. And then you could pass the home on to the next generation. So I'm going to pause here and see if folks have more questions.
Yes, we actually got some more really good questions. And the first one, excellent question. If only one heir cares for the property and pays the taxes for over 10 years, does that heir gain sole ownership? And the answer is no, you do not. And we get this question so often. And, so many times people come to us and say, but I've been paying the taxes for a gazillion years. I shouldn't have to go through this. This should be mine. Well, I'm sorry, but it's not. Paying the taxes is a great thing to do, because without paying the taxes, you could lose the property through a tax sale. And if you're the only one willing to step up and do it, and you really don't want to lose the property, then it's worth it to do that, but it's not going to give you any more interest than you would have as an heir, and it's definitely not going to give you sole ownership. It's still heirs property. So that is something you still have to deal with. Another great question is if the last living parent left several pieces of property to 6 children, and all of the children put the properties into an LLC, is it still heirs property? No, it's not. If you go through, all of the steps necessary and are able to put your property in an LLC, then you have just, cleared up the problem of heirs property. That is one tool that we use in our bag of tricks, is creating LLCs or family trusts for people with heirs property. If there are, especially if there are several children, well, they don't have to be several, but if there's more, a few people that want to be involved in the care of the property, and they work well together and kind of can delegate different duties and things like that, then that is sometimes a good way to go. Another good question we got was, how can you get insurance on heirs property? That is a really good question for an insurance agent. But our best guess is that it would be hard to get insurance on heirs property, because you would probably need to get everybody's, you would need to have an agreement, or you'd need to have a power of attorney so that you can make that type of decision for the property. But we are not insurance experts, so we would recommend asking an insurance agent about that, but we're thinking that there may be some hurdles trying to do that.
Wanda, do you want me to take a couple?
I was just looking at another good one. Can heirs sign off the property to other heirs if they have no interest in the land? You sure can. You can gift your interest to another heir, or ever how many heirs you want to. You can sell your interest. You don't have to hang on to it if you're not interested in it. So that's a very good question. And yes, you want to take some, Skipper?
There's a question: if a parent and adult child have their houses in the same trust, will both the parent and child qualify for homestead exemption? It depends on who the trustees are. And that is not a question we can answer without seeing the actual trust. And also, you can probably find out the answer by taking the trust document to your local tax office. There was a question of, are there any states with best and innovative practices in the area of reducing heirs property? It provides me a great deal of pride to say that Georgia is the leader, and we were the first state in the South to pass the Uniform Partition Act, and we are the only statewide heirs property center in the US. So as complicated as it is, we are basically in Georgia doing the best practices. Let's see. All the children members of an LLC have a voice in the property. Isn't that the same as heirs or not? Because it limits the number of potential additional people who would have a voice. I don't completely understand the question, but let me tell you this. If it's in an LLC, it means that the LLC itself owns it, and it's that one entity. And because it's a single entity, it is not heirs property. And the operating agreement within the LLC would dictate how decisions were made. But it is owned by one entity, so it would not be considered heirs property. How is individual interest determined if a party wants to sell? Gentry, do you want to answer that one? Because it's a whole, like, we have a whole heirs determination form, and it's based on when the timing of when people died and the percentage of heirs ownership. Gentry, take a stab if you don't mind. Wait, we can't hear you, Gentry.
It's just what the code says, and you've got to figure out.
Yeah, we actually can't hear you. So
Okay.
basically, it's determined by statute, and it's a matter of the timing of heirs are determined at the time of the deed owner's death, and then it depends on how many generations it goes through. It's sort of like going back, if you can imagine the presentation Delene made where she had the chart where she had mom and all the children. And so it all depends on who's living when mom dies and who's already predeceased her and how many children or grandchildren would end up owning it. That's pretty funny. I'm like, who's putting up the heirs property myths and facts? And it's Delene. I think that addresses all the questions. There is one question, what about abandonment rule? I'm not actually sure what rule you're referring to. You can own heirs property and not actually visit the property, and you still retain your interest. Should everyone involved have an attorney? It depends. I know that's not a very clear answer, but it depends on what the family relations are like and what the strategy and the intention is for clearing the heirs property. Are you going to keep it? Are there members who aren't interested? There are just a lot of moving parts to it. Are there any other questions? Okay, well, I think
I'll do the wrap up.
Yeah.
All right. So, again, just as a quick summary, having a will doesn't mean that you don't create heirs property, but having a will that is very intentional and leaves that real property to one person or perhaps one entity like a trust is the best way to prevent heirs property. And I'm hoping everyone leaves today with the understanding that everyone needs a will, whether you own real property, but especially if you own real property like a home or land. And then, of course, if you have minor children or if you're caring for a disabled adult, it's really critical to have your affairs in order for that next generation. And Skipper mentioned earlier, there was a question about safeguarding your documents.
Answer that question?
Yeah, these are particularly important documents. So we would recommend that you store them in a safe and accessible place. They shouldn't be stored in the testator's safety deposit box because then no one else can get at it. We heard a story earlier about someone who stored their handwritten will in a Prince album, and when they passed away, even Prince couldn't make sure that will would stand up in court. So we recommend that they be executed properly and then stored in a place where your executors can find it. And again, do not write on your will. Don't cross out any sections or words. This potentially invalidates the entire document. So we have on the Georgia Heirs Property Law Center's website a section called Publications. And in that publications link, we have a handbook, community estate planning for communities handbook. And that has a lot of the tips and things that we discussed, sort of the pitfalls, the myths and facts is also on that publications page, and other resources that as you're beginning to talk to your family members about potentially heirs property, or certainly when you're starting to think through your own estate plan, I'd highly recommend that you visit our website. I think the next slide is shows the web address, has our phone number, and talks about the publications page. This presentation is also available on, we'll put the PDF of this PowerPoint on the website, and it includes an appendix. There's some more slides that talks about the kinds of decisions and questions you need to ask before you speak with an attorney. And the other thing that we would really, really value, if you would be willing, is to answer a survey about this presentation. The feedback that you give to us and to Fort Valley and the other partners in this collaboration really helps us tailor these presentations and make sure that you get the information you want moving forward. So I believe with that, we have come to the
Well,
end.
actually, Wanda has a,
Ooh, another question?
she's going to answer a question.
Okay, go for it.
Yeah, so one more question is, how can one recover the money that's been paid for taxes on heirs property? That's a question we often get too. And again, I don't know if there's a real great answer other than it does depend. So, you know, if you sell the property and the proceeds are going to be dispersed to the heirs, you could potentially reimburse yourself out of the proceeds. You could also, if the property's not being sold or leased, you know, there's no money coming in from it, you can certainly ask the other heirs to, you know, contribute their portion of the taxes. Sometimes people, you know, will threaten to sue their family for the, you know, things like other expenses and taxes that they've had to pay out of pocket for. I suppose that's always an option. There's no guarantee you would win, but there's that option. So, you know, sometimes it just may not work out that you're able to get reimbursed. You know, that may be the case sometimes if you aren't selling the property. But I think that, you know, it depends. So that's about the best answer we can give you. I think that was all of the questions then.
All right, we have a hand up question from Ms. King.
Wait, I was
King.
trying to say something. Can you hear me?
Okay.
Okay,
Go ahead,
sorry.
Skipper, and then Ms. King will come to you in just a moment.
I just wanted to add to Wanda's
Okay.
comment. Part of the reason that we that the recovery of taxes is complicated and hard and always involves some kind of lawsuit unless your family is willing to pay you back, which is why we highly recommend before paying property taxes for all the heirs that you have a written agreement in writing is that you're going to pay the taxes, and how you will be paid back. It is through the proceeds from the sale of the property or income from the property. So that's it. Just have an agreement in writing.
Okay, Skipper, do we have a hand up from Ms. King? I'm assuming it's Belinda King, I believe it is.
Yes.
I don't. Or do you want to receive that?
Sure.
Okay. Ms. King, if you can unmute your mic and go ahead with your question.
I'm unmuted. Can you hear me?
We can. Yes, go ahead.
Do you hear me?
Yes,
Okay,
we can.
wonderful. Thank you so much for accepting my question. I wanted to ask, suppose you have several heirs and only a couple of them are actually interested in the property, and those few that are interested buy the others out. And in the midst of that, one of the people died. Where does that leave the ones that bought the other people out?
Uh, well, that's the beauty of heirs property is that that actually sometimes happens before you can get a situation cleared or get the title cleared. Sometimes some of the heirs pass away before you can finish, and so that just creates more heirs that you would continue going down that line. So the person that passed away, if they had children or a spouse, then they would then be added to the heirs. You have to just keep going down. And I have heard of situations where there were a lot of elderly people and they were passing away as the judge was trying to get the case completed, and it just keeps creating more heirs. So it can be problematic, but it is what it is, and you keep moving forward, adding those people, and then figuring up their interest just like you did everybody else.
But even if everybody in that heir's family line is willing to sell except a couple, then what? Even the wife.
So I think what you're saying is what if a few people aren't willing to sell their interest? And
yes.
I mean, they don't have to sell their interest. Like just, maybe you're talking about a family group. I'm not real sure. Or like several.
Yes, the one that passed away. The one that passed away. Everybody is with his wife, and all of his children are wanting to sell, but a couple of them, they're just not responding one way or the other.
Okay.
So this is, can you hear me?
Yes.
This really isn't the forum to be able to answer very specific personal questions. We can't really answer a question like this without having it in front of us and seeing who all of the heirs are and seeing what's been agreed to and what hasn't. So any further answer is just going to be a surmise. So do your best to get to speak to an attorney directly and privately.
Okay, thank you.
Okay. And thank you all for your questions. We do have, I think, another question in the chat, Skipper, that's not answered yet. And we, as mentioned, the slides.
Are you referring to the question about the father dying intestate? Brenda, is that the one you're talking about?
No, that's not it. I believe. Let's see.
I answered the intestate question. Oh, it was a direct message to me. I'm sorry.
Okay.
I see a question.
As Skipper is looking at that question so that she can answer it, let me just remind you all that the Georgia Heirs Property Law Center website is up, and as Delene mentioned, the slides will be posted on their website, so you can go back and visit the slides there, as well as on FVSUag YouTube page. The entire presentation will be there as well.
Okay,
Skipper.
I believe you were talking about can heirs lease or rent property without everyone in agreement? The answer to that is you would be skating on very thin ice. You can't, and if something were to happen and an heir got unhappy with you, there might be consequences. So that's not advisable.
Yeah, and we certainly
Okay.
encourage, if you have heirs property in the state of Georgia, please, our phone number is up on the screen. Extension 1 is sort of our intake line, and we'd welcome you to give us a call and see if we might be able to help you with your heirs property issue. But again, as Brenda pointed out, our website is up. We have lots and lots of resources. We have additional recorded webinars that you can play or email to a family member if you want them to see something in specific. So we really encourage you to get in touch with us and hopefully be able to get things sorted out for the next generation.
Okay, I think we have Millicent, we have a question coming in from Facebook as well. It's going to be posted in just a moment. I know that we're about 5 minutes before, about 4 minutes before our time. So please, if you do leave, take time and fill out the survey that's in the chat, that link, the evaluation before leaving.
So to answer the question that came through about a non-custodial parent's rights regarding a special needs trust and life insurance, etc., you are going to need to go see a family law attorney. That's not an area that we have expertise in.
And yes, somebody asked if the recording would be sent and made available. Yes, we will send the link to the recording out. It will also be posted at the Georgia Heirs Property Law Center's website under our webinars section, probably by early next week. And it'll be something that you can then repost and reshare. And in addition to the webinar, you'll also receive a link with the survey in it. So thank you.
So we again, thanks to everyone for joining us today. A lot of great information, and we thank you so much for taking time out of your schedule to join us. We will ask that you please, before you leave, go ahead and fill out the survey. We'll be here a few minutes, and so it is in the chat. That link is listed in the chat. You can click on that link and fill out the confidential evaluation. Please let us know. That will help us to better serve you in the future. So we would like to hear from you. Again, thank you so much. As mentioned, the Georgia Heirs Property Law Center website, their screen is still up with that website. It is also posted in the chat. It's Georgia GAHeirsProperty.org is their website. And the presentation for Facebook Live is streaming live. It also, we've listed the evaluation there in the chat of Facebook as well. So if you would fill out that evaluation for us, it would help us. And we thank you again for joining us. I hope the information was helpful to you, but before you leave, just take about 2 to 3 minutes and fill out that survey for us. As always, as we mentioned, the website for Valley State Extension is ag page, the FVSUag page, Facebook Live. The presentation is recorded there. You can go back and watch it again there, as well as on the Law Center if you need to. And for more information, you can contact the Law Center if you have more detailed questions. So we thank you. I hope this has been informative to you, and we look forward to bringing more programs that will assist you. I'm going to yield and ask Mr. Thomas if he wants to make any final comments before we leave out of here. Mark Thomas, County Director of Extension, Field Director for Fort Valley State University Extension. Mr. Thomas, are you there or are you
I
muted?
am
Okay.
now.
Okay.
Thank you,
Thank
President,
you.
for coordinating this program. Thanks to the lead skipper and all of her staff for a great program. On behalf of Fort Valley State, let me just say thank you to those remaining participants who are here with us. We thank you for your participation. We hope to, as Fort Valley State, we hope to continue to partner with agencies, stakeholder agencies like the Air Property Law Center and others to bring you programs that may go beyond the scope of where we are. As you all know, we at Fort Valley State, we are not necessarily attorneys, but we did want to partner with other groups that are experts in this area for a much needed and a very important topic, especially in today's time. So we thank you for coming. We wish you nothing but health and prosperity in your future endeavors, and continue to monitor our website at Fort Valley State University Extension and College of Ag, as well as we continue to bring you programs like this and others as it relate to ag and natural resources, family and consumer science, and 4-H and youth development. So with that, again, thank you all, and you all enjoy the rest of your day. And don't forget to complete the survey.
Thank you, Mr. Thomas. And we are done. Again, we ask before you leave, if you haven't already done so, please share your thoughts with us. It's going to help us, and we're going to remain open here a few minutes for those of you that might be clicking on that link. I just reposted it again. But those of you that have what you need and have completed the survey, we thank you for joining us, and have a great lunch break.
Thank you.
Thank you.
Thank you and good job.
Thank you.